Article 1, Section 8 is one of the most important parts of the Constitution. In this section we find the powers specifically granted to Congress, enumerated powers as they are often called.
Article 1, Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States. To regulate commerce with foreign nations and among the several states and with the Indian tribes. To establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States. To establish post offices and post roads. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. To constitute tribunals inferior to the Supreme Court. To define and punish piracies and felonies committed on the high seas, and offenses against the law of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. To raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. To provide and maintain a navy. To make rules for the government and regulation of the land and naval forces. To provide for calling forth the militia, to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may by cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof.
These enumerated powers, as we shall see, are among the most important and controversial parts of the Constitution. How did they find their way into the Constitution? Well, the original Virginia plan, on which much of the Constitution was based, did not include an enumeration of powers. Rather, it specified that Congress should, in its words, legislate in all cases to which the separate states are incompetent. This provision was accused of vesting Congress with indefinite powers. Edmund Randolph, who had introduced the Virginia plan, denied the intention. Then James Madison, who had authored much of the Virginia plan, stated his views on the enumeration of powers.
I brought with me into this convention a strong bias in favor of an enumeration of and definition of the powers necessary to be exercised by the national legislature. But I also brought doubts concerning its practicability. My wishes remain unaltered, but my doubts have become stronger. What my opinion might ultimately be, I cannot yet tell. But I should shrink from nothing which should be found essential to such a form of government as would provide for the safety, liberty, and happiness of the community. This being the end of all our deliberations, all the necessary means for attaining it must, however reluctantly, be submitted to.
Madison shared the concern of many delegates who favored a strong central government. An enumeration of congressional powers, these nationalists feared, might eventually tie the hands of the central government. Nationalists had vigorously criticized the Articles of Confederation as too weak and inflexible to deal with America's problems, and the Articles granted to Congress only those powers expressly delegated to it by the states. Nationalists wanted to avoid the same mistake in the Constitution. 6 weeks after Madison's comment, the problem of enumerated powers surfaced again. South Carolina's Pierce Butler voiced his concern over the proposed power of Congress to legislate where individual states are incompetent.
I call for some explanation on the extent of this power, particularly of the word incompetent. The vagueness of the terms renders it impossible for any precise judgment to be formed.
Nathaniel Gorham from Massachusetts responded.
The vagueness of the terms constitutes the propriety of them. We are now establishing general principles to be extended hereafter in details, which will be precise and explicit.
The convention, Gorham believed, would eventually hammer out a list of specific congressional powers. He was right. On July 26th, after 5 weeks of debates and compromises, the convention adjourned to allow a 5-man committee of detail to draft a preliminary version of the Constitution. 10 days later, the committee submitted its draft. It enumerated 18 powers of Congress, and these were similar to the 18 powers which eventually were included in the final Constitution. How did the Committee of Detail arrive at its list of powers? The answer to this question involves one of the most controversial and maligned delegates to the Federal Convention, South Carolina's Charles Pinckney. On the 3rd day of the convention, after Edmund Randolph had submitted the Virginia Plan, Charles Pinckney submitted his own plan for a constitution. Unlike the Virginia Plan, Pinckney's plan contained a list of enumerated powers. This plan was ignored by the convention, but the Committee of Detail apparently drew from it when formulating its list of enumerated powers. Here we enter murky water, because the exact content of Pinckney's draft is something of a mystery. The original copy did not survive. So many years after the convention, as the official records were being readied for publication, Pinckney was asked to supply a copy of his plan. Pinckney happily complied, and the document he sent bears a striking resemblance to the finished Constitution. Indeed, it made Pinckney look like a major architect of the Constitution. After the Pinckney plan was printed, Madison was outraged. Pinckney, Madison suggested, had doctored his plan after the fact, so as to conform with many features of the final Constitution. In 1830, Madison said he was going to write to Pinckney, asking and even requiring an explanation. Unbeknownst to Madison, however, Pinckney had died years before, so the mystery of Charles Pinckney remained unsolved. Was Charles Pinckney an unsung father of the Constitution? Modern historians are divided on this controversy. Madison's distinguished biographer, Irving Brandt, calls Pinckney a sponger and a plagiarist. Other historians have come to Pinckney's defense, however. According to one account of the Constitutional Convention, Pinckney was cheated of credit for his role in modeling the Constitution by James Madison and his supporters. Pinckney's defenders have credited him with originating between 21 and 43 provisions of the final Constitution. Pinckney agreed that he had been robbed of credit as an architect of the Constitution. His insistent claims led his colleagues to saddle him with the sarcastic nickname of Constitution Charlie. Well, did Constitution Charlie originate the enumeration of congressional powers found in the Constitution? Most likely, yes. From Madison's own convention record, we know that Pinckney objected to the vague wording of the Virginia Plan, which gave Congress power to legislate in all cases to which the state legislatures are individually incompetent. Early in the convention on May 31st, Pinckney said,
I object to the vagueness of the term incompetent. I cannot well decide how to vote until I see an exact enumeration of the powers comprehended by this definition.
Article 1, Section 8 of the Constitution contains 18 clauses which enumerate the powers of Congress. Among these powers, the first and last have proved the most important and controversial. Therefore, we shall focus on these 2 clauses. The first clause of Article 1, Section 8 reads, in part,
The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States.
This is one of the most important sentences in the Constitution. It vests a taxing power in Congress, a power it was denied under the Articles of Confederation. And it contains the famous General Welfare Clause, which has been subjected to a variety of interpretations. Basically, this sentence can be, and has been, interpreted in one of two ways, depending on the emphasis given to an all-important comma. This comma appears after the words, "The Congress shall have power to lay and collect taxes, duties, imposts, and excises." A comma is inserted at this point, after which the sentence continues, "to pay the debts and provide for the common defense and general welfare of the United States." Here is the basic controversy. Is Congress empowered to levy taxes for the purpose of providing for the general welfare of the United States? Or is Congress empowered to levy taxes and then empowered to provide for the general welfare of the United States as a separate and distinct power? This may seem to be an exercise in semantics, but it is of great importance. If the General Welfare Clause is not tied to taxation, if Congress is authorized to provide for the general welfare as a separate and distinct power, then Congress is given enormous power when implementing what it considers necessary for the general welfare. The wording of this clause is ambiguous. Fortunately, however, framers of the Constitution were clear about its intended meaning. In the Federalist Papers, for example, James Madison argued for a restricted interpretation. The words common defense and general welfare, he pointed out, had been taken from the Articles of Confederation. In that document, these words had not been used to confer a general power on Congress to promote the general welfare. In the same way, according to Madison, when framers of the Constitution included the words common defense and general welfare in the Constitution, they had no intention of conferring an indefinite power on Congress to promote the general welfare.
For what purpose could the enumeration of particular powers be inserted, if these and all others were meant to be included in the preceding general power? What would have been thought of the convention delegates if, attaching themselves to these general expressions and disregarding the specifications which ascertain and limit their import, they had exercised an unlimited power of providing for the common defense and general welfare?
Article 1, Section 8, according to Madison, empowers Congress to levy taxes for the purpose of providing for the common defense and general welfare of the United States. Article 1, Section 8 does not give Congress a general mandate to promote the general welfare. Well, Madison had a strong case. We can see this by tracing the evolution of the General Welfare Clause during the Constitutional Convention. On August 6th, the Committee of Detail reported its rough draft of the Constitution. This draft never used the words common defense and general welfare. It stated simply, the legislature of the United States shall have the power to lay and collect taxes, duties, imposts, and excises. 12 days later, on August 18th, the convention debated whether Congress should be empowered to pay off not only its own war debts, but the war debts of individual states as well. South Carolina's John Rutledge suggested forming a committee to consider this question. His motion included the words, common defense.
I move that a grand committee be appointed to consider the necessity and expediency of the United States assuming all the state debts. A regular settlement between the Union and the several states will never take place. The assumption would be just, as the state debts were contracted in the common defense.
A committee was formed to consider the problem of state debts. Known as the Committee of 11, its report was presented on August 21st by New Jersey's William Livingston. Here, for the first time during the convention, the words common defense and general welfare made their appearance.
The legislature of the United States shall have power to fulfill the engagements which have been entered into by Congress, and to discharge as well the debts of the United States as the debts incurred by several states during the late war for the common defense and general welfare.
Ultimately, the convention voted against this provision. It did not empower Congress to pay off state debts accumulated during the war. The convention returned to the original wording of the Committee of Detail, where the words common defense and general welfare were not used. On August 25th, however, as delegates were discussing how to pay off the public debt, Connecticut's Roger Sherman moved to reinsert the words common defense and general welfare.
I think it necessary to connect with the clause for laying taxes, duties, etc., an express provision for the object of old debts. I move to add to the power to lay and collect taxes, duties, imposts, and excises the words, for the payment of said debts, and for the defraying the expenses that shall be incurred for the common defense and general welfare.
Sherman's extra words were objected to as unnecessary, and his motion failed to pass. Days later, however, after more debate on the public debt, the Committee of 11 wrote another report. Presented by New Jersey's David Brearley, this report reinserted the words common defense and general welfare.
The legislature shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States.
This version is virtually identical to the clause eventually included in the Constitution. Significantly, small state men like Roger Sherman and David Brearley were behind the effort to include the words common defense and general welfare. These words, in their view, restricted the taxing power of Congress, as Roger Sherman said in a letter written shortly after the convention.
The objects for which Congress may apply monies are the same mentioned in the 8th article of the Confederation. That is to say, for the common defense and general welfare.
Nationalists were not entirely happy with this restriction on congressional taxing power, but Pennsylvania's Gouverneur Morris, a fervent nationalist, made a last-ditch effort to turn a minor defeat into a major victory. Morris wrote the final draft of the Constitution, and in so doing he took some liberties. After the words to lay and collect taxes, duties, imposts, and excises, Morris inserted a semicolon instead of a comma. As the historian Forrest McDonald has noted, that would have transformed the subsequent words to pay the debts and provide for the common defense and general welfare of the United States into a positive and broad grant of power. Roger Sherman detected this little trick by Morris, and the original comma was restored. Thus, the general welfare clause again became what it was intended to be, a restriction on the powers of Congress. If Article 1, Section 8 restricts the powers of Congress, critics of the Constitution did not believe it restricted them enough. This section begins,
The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States.
This section, critics charged, grants to Congress unlimited powers to tax. Congress can tax without restraint. Luther Martin, a Maryland delegate to the Philadelphia Convention, was outraged.
By the power to lay and collect imposts, Congress may impose duties on any or every article of commerce imported into these states, to what amount they please. By the power to lay excises, a power very odious in its nature, since it authorizes officers to go into your houses, your kitchens, your cellars, and to examine into your private concerns, the Congress may impose duties on every article of use or consumption, on the food that we eat, on the liquors we drink, on the clothes that we wear, the glass which enlighten our houses, or the hearths necessary for our warmth and comfort. By the power to lay and collect taxes, they may proceed to direct taxation on every individual, either by a capitation tax on their heads or an assessment on their property. By this part of the section, therefore, the government has a power to tax to what amount they choose, and thus to sluice them at every vein, as long as they have a drop of blood, without any control, limitation, or restraint.
Melancton Smith, the leading opponent of the Constitution in New York, believed governmental powers should be clearly defined.
It is necessary that the powers vested in government should be precisely defined, that the people may be able to know whether it moves in the circle of the Constitution.
Article 1, Section 8 is intolerably vague, Smith continued, so the federal government will push its taxing power to the limit.
It is a general maxim that all governments find a use for as much money as they can raise. Indeed, they have commonly demands for more. Hence it is that all, as far as we are acquainted, are in debt. I take this to be a settled truth, that they will all spend as much as their revenue. That is, will live at least up to their income. Congress will ever exercise their powers to levy as much money as the people can pay.
Article 1, Section 8 says Congress can tax, but it does not say how much Congress can tax. This, according to critics of the Constitution, is like giving Congress a blank check. Alexander Hamilton responded to this objection in the Federalist Papers. Hamilton stressed the importance of revenue to a government.
A nation cannot long exist without revenue. Destitute of this essential support, it must resign its independence and sink into the degraded condition of a province. This is an extremity to which no government will of choice accede. Revenue, therefore, must be had at all events.
Money, Hamilton maintained, is the very lifeblood of government.
Money is, with propriety, considered as the vital principle of the body politic, as that which sustains its life and motion and enables it to perform its most essential functions. A complete power, therefore, to procure a regular and adequate supply of revenue, as far as the resources of the community will permit, may be regarded as an indispensable ingredient in every constitution.
For Hamilton, the case was clear. If the national government is charged with certain responsibilities, then logically it must have the right to use whatever means are necessary to discharge those responsibilities.
Whether there ought to be a federal government entrusted with the care of the common defense is a question in the first instance open to discussion. But the moment it is decided in the affirmative, it will follow that that government ought to be clothed with all the powers requisite to complete execution of its trust.
No constitutional limit should be placed on taxes, Hamilton argued, because we cannot predict the future.
These powers ought to exist without limitation, because it is impossible to foresee or to define the extent and variety of national exigencies, and the correspondent extent and variety of the means which may be necessary to satisfy them.
The Constitution empowers the Congress to provide for the common defense. An unlimited power to tax is necessary to achieve this goal.
The circumstances that endanger the safety of nations are infinite, and for this reason no constitutional shackles can wisely be imposed on the power to which the care of it is committed. This power ought to be coextensive with all possible combinations of such circumstances, and ought to be under the direction of the same councils which are appointed to preside over the common defense.
Hamilton made this point repeatedly in the Federalist Papers.
As the duties of superintending the national defense and of securing the public peace against foreign or domestic violence involve a provision for casualties and dangers to which no possible limits can be assigned, the power of making that provision ought to know no other bounds than the exigencies of the nation and the resources of the community.
James Madison agreed with Hamilton's reasoning. National defense is a primary responsibility of the central government.
Security against foreign danger is one of the primitive objects of civil society. It is an avowed and essential object of the American Union. The powers requisite for attaining it must be effectually confided to the federal councils.
In addition to taxation, Article 1, Section 8 enumerates other powers necessary to national defense, including the power to raise and support armies. All such powers, Madison contended, ought to be unlimited, because a nation cannot foresee or control future threats to its security.
With what color of propriety could the force necessary for defense be limited by those who cannot limit the force of offense? If a federal constitution could chain the ambition or set bounds to the exertions of all other nations, then indeed might it prudently chain the discretion of its own government and set bounds to the exertions for its own safety. How could a readiness for war in time of peace be safely prohibited unless we could prohibit in like manner the preparations and establishments of every hostile nation?
Thus, in the Federalist Papers, both Hamilton and Madison argued vigorously against restricting the congressional powers enumerated in Article 1, Section 8, especially the power to tax. Enumerated powers specify the purposes for which Congress can tax, but within these boundaries there should be no limits on the amount Congress can tax. Hamilton summarized the basic principle involved.
A government ought to contain in itself every power requisite to the full accomplishment of the objects committed to its care, and to the complete execution of the trusts for which it is responsible, free from every other control but a regard to the public good and to the sense of the people.
The struggle to ratify the Constitution of the United States was lively and bitter. Opponents of ratification often criticized the immense powers which the Constitution gives to the central government. Many parts of the Constitution were attacked, but none was castigated with more vehemence than the final clause in Article 1, Section 8.
The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof.
This famous necessary and proper clause is often called the elastic clause. Why? Because through centuries of judicial interpretation, this clause has been used to expand the powers of Congress. It enables Congress to make all laws which are necessary and proper to discharge its constitutional duties. In so doing, this clause has opened to Congress a vast arena of discretionary powers, that is, powers not expressly granted by the Constitution. During the ratification struggle, Hamilton observed, the necessary and proper clause was a center of controversy.
This clause has been the source of much virulent invective and petulant declamation against the proposed Constitution. It has been held up to the people in all the exaggerated colors of misrepresentation as the pernicious engine by which their local governments were to be destroyed and their liberties exterminated, as the hideous monster whose devouring jaws would spare neither sex nor age, nor high nor low, nor sacred nor profane.
Hamilton's remarks were something of a caricature. Many Americans were legitimately concerned that the necessary and proper clause would be used to justify the continuous expansion of the federal government. One critic of the Constitution expressed this concern emphatically.
Under such a clause as this, can anything be said to be reserved and kept back from Congress? Can it be said that the Congress have no power but what is expressed? To make all laws which shall be necessary and proper is, in other words, to make all such laws which the Congress shall think necessary and proper. For who shall judge for the legislature what is necessary and proper? Who shall set themselves above the sovereign? What inferior legislator shall set itself above the supreme legislature? What limits are there to their authority? I fear none at all. For surely it cannot justly be said that they have no power but what is expressly given to them, where by the very terms of their creation they are vested with the powers of making laws in all cases necessary and proper, when from the nature of their power they must necessarily be the judges what laws are necessary and proper.
In the Federalist Papers, Madison and Hamilton defended the necessary and proper clause. In their eyes, the need for this clause was virtually self-evident. As Madison wrote,
Few parts of the Constitution have been assailed with more intemperance than this. Yet on a fair investigation of it, no part can appear more completely invulnerable. Without the substance of this power, the whole Constitution would be a dead letter. Those who object to the article, therefore, as a part of the Constitution, can only mean that the form of the provision is improper. But have they considered whether a better form could have been substituted?
According to Hamilton, if a government has certain duties, then logically it must possess the means to discharge those duties.
What is a power but the ability or faculty of doing a thing? What is the ability to do a thing but the power of employing the means necessary to its execution? What is a legislative power but a power of making laws? What are the means to execute a legislative power but laws? What is the power of laying and collecting taxes but a legislative power, or a power of making laws to lay and collect taxes? What are the proper means of executing such a power but necessary and proper laws?
It is nonsense, Hamilton argued, to tell a government to do something and then to tie the government's hands. It is a self-evident truth that a Congress charged with certain responsibilities also must be charged with the means necessary and proper to meet those responsibilities.
This clause authorizes the national legislature to pass all necessary and proper laws. If there be anything exceptionable, it must be sought for in the specific powers upon which this general declaration is predicated. The declaration itself, though it may be chargeable with tautology or redundancy, is at least perfectly harmless.
If the necessary and proper clause is self-evident and harmless, then why was it put in the Constitution in the first place?
The convention probably foresaw that the danger which most threatens our political welfare is that the state governments will finally sap the foundations of the Union, and might therefore think it necessary, in so cardinal a point, to leave nothing to construction.
Next, Hamilton responded to a criticism commonly hurled at the necessary and proper clause.
It may be asked, who is to judge of the necessity and propriety of the laws to be passed for executing the powers of the Union? I answer that the national government, like every other, must judge in the first instance of the proper exercise of its powers, and its constituents in the last. If the federal government should overpass the just bounds of its authority and make a tyrannical use of its powers, the people, whose creature it is, must appeal to the standard they have formed, and take such measures to redress the injury done to the Constitution as the exigency may suggest and prudence justify.
According to Hamilton, if a government is to function effectively, it must possess not only those powers expressly delegated to it, but implied powers as well. In order to implement its laws, a government must have discretionary powers at its disposal. Many opponents of the Constitution disagreed. They believed a government should have only those powers expressly delegated to it by the people. Mercy Warren explained how this controversy over expressed powers led some Americans to oppose the Constitution.
These objections were not the result of ignorance. They were made by men of the first abilities in every state. Men who were sensible of the necessity of strong and energetic institutions, and a strict subordination and obedience to law. These judicious men were solicitous that everything should be clearly defined. They were jealous of each ambiguity in law or government, or the smallest circumstance that might have a tendency to curtail the republican system or render ineffectual the sacrifices they had made for the security of civil and religious liberty to themselves. They also wished for the transmission of the enjoyment of the equal rights of man to their latest posterity. They were of opinion that every article that admitted of doubtful construction should be amended before it became the supreme law of the land. They were now apprehensive of being precipitated, without due consideration, into the adoption of a system that might bind them and their posterity in the chains of despotism.
Compare this position to that of James Madison, who warned what will happen if the Constitution restricts Congress to expressed powers.
The new Congress would be continually exposed, as their predecessors have been, to the alternative of construing the term expressly with so much rigor as to disarm the government of all real authority whatever, or with so much latitude as to destroy altogether the force of the restriction.
The problem of expressed powers was a sensitive issue for critics of the Constitution. They feared the government, in exercising its necessary and proper discretionary powers, might trample on individual rights. Therefore, many Americans wished to restrict the power of government by including a Bill of Rights in the Constitution. They got their wish 3 years after the Constitution had been ratified. In 1791, the first 10 amendments to the Constitution, the Bill of Rights, expressly limited the powers of the American government.
We hope you've enjoyed this presentation of the U.S. Constitution by Knowledge Products. The script for the text of the Constitution is by George H. Smith. The producer is Pat Childs. Acting coach is Ruth Sweet. Voice characterizations are by Pat Childs, E.R. Davies, Craig Deichman, Michael Edwards, David Ford, Travis Hardison, Don Jones, John Lutz, Sam Mercurio, Michael Montgomery, Hugh Sinclair, Sam Chuchavas, and Robert Wynn. Music is by Ralph Childs. Produced at Archer Productions, Nashville, and Sync Sound, New York. This material may not be copied in whole or in part without the written permission of the copyright owner. Copyright 1987 by Carmichael and Carmichael Incorporated.